Finally, I think it is worth mentioning a doctrine that the Inter-American Court created in 2006 called Conventionality Control. The court first mentioned this doctrine in the case Almonacid versus Chile. In that judgment, the court stated that all bodies of the state have the obligation to confront their national legislation with the American Convention on Human Rights and the case law of the court, so that if domestic legislation is contrary to them, the domestic body shouldn't apply it. Domestic bodies would have to do so even if the domestic norm is part of the Constitution and it only goes against what the Inter-American Court decided on a single case, which is a significant thing to say. This doctrine is against the original findings of the Inter-American Court, which used to say that it was for the states to define the way in which they incorporate the American Convention on their domestic legal systems. The doctrine of conventionality control has no real ground on the text of the American Convention on Human Rights, and this may be a reason why it has evolved since 2006 in ways that are not necessarily consistent. As a result, the content of the doctrine is still unclear, and different judges have diverse opinions about the extent of conventionality control, so it is still to see whether the court will moderate its content. As you can see, for the moment, the doctrine of conventionality control is quite unconventional, especially because it goes against some basic notions of international law. For instance, the one saying that it is states themselves who are entitled to define how and to what extent they incorporate international law into municipal law. Conventionality control is also oblivious to the fact that the court has the power to interpret the American Convention only in individual cases, without generating binding precedents, because the Convention didn't give it that power. Another issue is that the court seems to forget the distinction between monist and dualist states. These are only a few problems of the doctrine of conventionality control. Other problems may be found in some literature on the matter. It is also important to note that few states have accepted the doctrine of conventionality control, at least in the sense that the Inter-American Court gives it. Most states under the jurisdiction of the court accept that it is necessary to confront national legislation with international treaties, but they reject the idea that national legislation should be considered automatically abrogated by international law. However, some high courts use the concept conventionality control, which in Spanish is very similar to judicial review, as a way of referring to the idea of comparing national legislation with international treaties. So you can see that they use this concept, but not in the sense that the Inter-American Court gives it. Well, this was a short and introductory description of the Inter-American human rights system. Now you know how to issue a petition before the Inter-American Commission, which, as you saw, is something very easy and can be done by any state member of the OAS, by any individual claiming that a state member of the OAS violated his or her human rights, regardless of whether the state has ratified the American Convention on Human Rights. There is much written about this human rights system, so you may wish to learn more about the case law of the Inter-American Court, which is very interesting, but too broad as for talking about it in a single class. For more information, you may go to the website of the Inter-American Commission or the Inter-American Court, which are full of information, both in English and Spanish, although, unfortunately, the judgments of the Inter-American Court have not been translated into English in recent years. Well, thank you again for joining me on this class, and I encourage you to learn more about this system that has been useful, very useful for the protection of human rights in the Americas, but which is at the same time controversial in some respects. Thank you again for joining us. See you. Adios.